Hello, my name is Andy Littlefield, and this is a module about the background to getting probate. The intention is to make three such webinars. One is about the initial steps, which is this module. The second one is the steps about preparing to make your application, and the third step is about making the application itself. I just want to start with a little disclaimer for legal reasons. Everything here is as up to date and accurate as I can make, but the purpose of these talks is to give information and help you along the step of applying for probate if you want to do it yourself. So there is a disclaimer which you'll find on our website, which is www.willsadvice.wales/terms of use /. So having got that little bit out of the way, I'm going to press on to introduction. And that is basically, first of all, to explain who this talk is really intended to. So if you're going to, it's intended for two types of people. One is obviously the sort of person who wants to do it himself. Now, I meet lots of these people, and I always say, fair play, walk power to your elbow, do it yourself if you want to. The other sort of person this is intended for is the sort of person who is quite happy to use an expert, a solicitor or probate practitioner, but really wants to understand what is going on. A lot of people, it's the same with conveyancing, which I've done a lot of. You instruct a solicitor to do some probate on your behalf. Then there's a long pause, and then you get some money together with a bill for what seems to be an eye-watering amount. And you think, well, what on earth was done to deserve these costs? And this talk, I hope, will help you understand the process going on there. If you want to do it yourself, you will, of course, save costs, and you will also control the process going on. But I should stress, and we'll come to this point several times in the talk, that this is not for everyone. The analogy I always draw is servicing your car. If you want to service your car, fair play. You get the tools, you get the handbook, and you get stuck in. Speaking for myself, I would never, ever service my own car because I'd be a danger to everyone else. It's just not my sort of thing. So I'm quite happy to instruct a garage expert to do the service for me. It's the same with probate. In order to do your own probate, you need certain qualities. You need to be organized. You need to be meticulous. You need to keep careful records. You need to understand what you're doing. So you need to do the research into the background and understand why you're doing what you're doing. I suppose even more particular, you need to understand it is quite hard work. Depending on how much is in the estate, you need to contact the various organizations, the banks, the building societies, get valuations on your property and so on. So you need to be patient as well. And you need to keep careful records. I suppose that's the other thing. If you're anything like me, you want to skip this bit and just dash on to applying for probate because you just want to fill out the form. I'm saying that these talks are really for to help you understand what's going on and to concentrate on doing this particular module because it explains the background and the terminology involved. So then moving on to that very terminology, it's a legal process, it's a legal thing. So I know some people think these are just words and just lawyers trying to sound, what's the word, difficult or clever. But there is a reason and a thinking behind each of the terms and behind each of the procedures. So you need to stick with it. But on the other hand, don't be scared of it. It's not that difficult. Once you get behind the terminology, particularly if the estate is straightforward and there are no complications, which again is something I hope to come to later on. As long as the estate is simple and straightforward, if you've got the qualities I mentioned before, you can do it yourself. So stick with it. So just a little paragraph about the duties of executor, because you need to know this right off, and I will come to this again later on in the talk. Executor is the center of all what's going on. So you need executor as a person who's tasked by the testator, if there is a will, to do what's necessary. And what's necessary, essentially, is selling the assets in the estate, converting them, in other words, into cash, and then distributing those assets in accordance with the will. And as I'll explain again later on, I'll stress more later on, it's a personal liability. If you get it wrong, if you make mistakes, then it's going to be your duty as executor, your personal duty as executor to put it right. So if there's anything unclear, it's not certain about anything, it's getting out of control, go to a lawyer and they'll do it for you. So I'll go on to who this doesn't apply. There's certain cases where I would advise, it's entirely up to you. I know someone who had to deal with quite a large estate on behalf of his family and did it perfectly well. So you don't have to go to a lawyer, but there's some cases where it is important to think about that possibility. One is where you can't find a beneficiary. Now, sometimes a beneficiary simply disappears. You know, say a brother has disappeared, has gone abroad to Australia. You don't know if he's still alive. You don't know how to find him. And in those circumstances, you need to be careful. There are procedures you can follow, which I deal with in another module. There are procedures you can take to protect yourself. But if you distributed the money without trying to take those procedures, then you could find yourself as an executor personally liable if that beneficiary suddenly comes out of the woodwork and wants his money. And that has happened. Similar with the original will, you should produce the original will. Now, the point there is that sometimes it's not clear what the original will is. There's a well-known case of someone who produced 4 wills, all in 1 year. Each will contained a revocation clause, and none of the wills were actually dated, so it was impossible to say which was the original will. And in that case, she might as well not bother making any because she was basically intestate. But it's important to try and produce, not try, it's important to produce the original will. Usually not a problem, but if it is a problem, you might need to take special steps to protect yourself. Another case where you should really go to a lawyer is where there's a dispute within the family. Sadly, this is possibly on the increase, but if there's any indication of the will being disputed by members of the family, there's people saying they're going to challenge the will, whatever like that, it's not worth trying to do it yourself. You might as well just take the cost and get to a lawyer and get them to front it up for you. The final thing where I would really say you should think about, not don't have to, it's entirely your choice, but going to a lawyer is where there's what I call complex financial affairs. This is family business or trust. I would also say if there's complex tax affairs which you don't want to get involved in. But a trust, for instance, is a complex matter to understand. And if you've got a trust set up particularly for children or for where there's a disabled person, a trust set up to protect a disabled person, unless you're willing to get to grips with the minutiae of dealing with trusts, you should really go to a lawyer who's been trained in this sort of area.